First tonight, the International Criminal Court has issued arrest warrants for the Israeli Prime Minister Benjamin Netanyahu and the former Israeli Defense Minister Yoav Gallant over the war in Gaza. The court rejected Israel's challenge to its jurisdiction. The ICC said in its pre-trial chamber that there are reasonable grounds to believe that both individuals intentionally and knowingly deprived the civilian population in Gaza of objects indispensable to their survival, including food, water, medicine and medical supplies, as well as fuel and electricity. The court has also issued a warrant for the Hamas military commander Mohammed Deif.
As I said before, the tragedy in Gaza has to stop. And now I will be very sober in my comment. It is not a political decision. It is a decision of a court of justice, of the International Court of Justice. And the decision of the court has to be respected and implemented. So I take note of the decision of the International Criminal Court to issue arrest warrants from Prime Minister Netanyahu, the former Minister of Defense, Mr. Gallant, and the Hamas leaders, Deif. This decision is a binding decision, and all states parties of the court, which include all members of the European Union, are binding to implement this court decision.
And that's the EU Foreign Policy Chief, Joseph Borrell, there. Well, let's speak now to the former president of the International Criminal Court, Judge Chile Ebo Osuji, who joins me now on the line from Toronto, Canada. Judge Osuji, thank you very much indeed for joining us. How significant is this move to issue these arrest warrants for the Israeli Prime Minister Benjamin Netanyahu and the former Israeli Defense Minister Yoav Gallant?
Well, it is significant in the sense that it underscores the current state of international law, which is that nobody is above it. Nobody is above international law. Nobody enjoys immunity. And we have, as you saw there in that clip from the EU Foreign Chief, Mr. Borrell, that the court decision is binding on 124 member states of the Rome Statute, and all members of the European Union are members of the court, and most. So that tells you that. I mean, Canada is a member of the ICC. Australia is a member of the ICC. New Zealand is a member of the ICC. They're not members of the EU, but that begins UK, members of the ICC. So that expands the scope of the importance or significance of what has happened here, meaning that none of those individuals who are now under an arrest warrant may go to those states and hope and take it for granted that they will not be arrested. So that kind of freedom is over now for them.
It's what it is in principle, isn't it, that it does restrict their movements. But we've seen other leaders who are accused of war crimes managing to go about their business without too many restrictions. Is there any chance that these arrest warrants will ever be executed?
Of course, there is a chance that they will be executed. First of all, while the people are in power, they will not be traveling to a lot of the states that are members of the Rome Statute. Oftentimes, we tend to underplay the significance of that, the arrest warrant itself alone. Giles, if you and I want to go on holiday to France, we'll hop on a plane and go. If we want to go, I know you're also British, you can hop on the plane, come to Toronto. I can hop on the plane, go to London, and not all I have to worry about is can I afford to go. Now, we have now a scenario where heads of state, heads of government, that will have to be a risk for them. What should be a dignified affair, they will go to places where they'll be treated with, people will roll out the red carpet at the airport. That no longer happens. They have to be calculating, should I go there? Should I not go there? Would I be arrested? That is not at all a dignifying position to be in. So ICC has done its work. The ICC judges and the chief prosecutor. It is now up to the member states of the Rome Statute to do their bit. And there may well be other states who may join the ICC in future to increase the number from 124 to more. But the point here is that oftentimes when people are not arrested, people under ICC arrest warrant are not arrested. People look, oh, ICC, have you failed? No. The fault for that is not on the ICC. The blame must be on the states who have the obligation to make international law work, to make the ICC processes work, and they don't do their part. When the ICC has done its part, done the heaviest lifting of saying, we are going to issue the arrest warrant, it is a major move. And it's up to the other states to do that. So if they don't, the shame of it will not be on the ICC, but it will be on those states who refuse to make the system work as it should.
It's fascinating, your analysis there, and it's very interesting that this is an issue that you deal with quite in some detail in your book, End of Immunity, which has been just got some really very good reviews. We're looking at that book now on the screen, and it talks about accountability for wars of aggression, war crimes, etc. So it's almost sort of prophetic in these circumstances.
The book had to be written when I left the ICC in 2021. That was one of the projects I undertook because I wanted to put the discussion beyond theoretical debate. The book tells the in-depth story of that change or that reform of international law that began in 1919. It was a new idea, more or less revolutionary, as it were, in 1919, after the First World War. But by 1945, it was no longer a new idea. 1945, the Nuremberg trials brought home that norm and made it specific. And you saw the prosecution of the surviving members of the Third Reich, all of them who survived were prosecuted. In Japan, all members of the Japanese Imperial War Cabinet were prosecuted. The emperor, of course, was not, because of political reasons. The Americans wanted to spare him so that they can govern Japan peacefully. But everybody else was prosecuted, and that was basically the crystallization of that norm, that there is no immunity for anyone, however big you are in hierarchy, however powerful you are in power. So that is the norm, and it's important to stress here that that norm was so crystallized in 1945 at the point when, at the time when we did not have yet a state of Israel. It's important to stress that. So this is an old norm that guides international law as we speak, and it's important for people to pay heed to it, else they end up with the kind of stories that made you invite me to this interview.
But it is interesting, beyond your very well sort of written and very well received book there, beyond that, the Israelis have argued that the International Criminal Court doesn't have any jurisdiction to deal with the complaints by the Palestinians, because according to the statute of the court, only states can be party to the statute, and a Palestinian state doesn't exist. I mean, is that a plausible argument?
Not at all. Not at all. In international law, it's a matter of it's not about the recognition of anybody that makes a state that. The parameters of international law, statehood, set out. There was a document called the Montevideo Convention on Rights and Duties of States that specify the criteria for statehood, and Palestine, meets those. And Palestine has been admitted as a member state of the Rome Statute. We can discuss this in detail if you want, but if you looked at when Israel declared independence in 1948, it was, I think, July 1948, only one state recognized it immediately. It took a while for more states to recognize it. Now, if you looked at the point that Palestine declared itself a state, it has gathered, you would say, more recognition by other states than Israel had at the same point between then and now. So we cannot make that argument that Palestine is not a state. Palestine is a state. The UN recognizes Palestine as a state, the UN General Assembly. The fact that it is not admitted to the membership of the United Nations does not mean that it is not a state. Switzerland for a long time was not a member state of the United Nations, but no one ever argued that at that time Switzerland was not a state because it wasn't a member of the UN. So Palestine meets all the requirements of statehood. It's just that it is under occupation at a state, and being at a stage and being under occupation does not deprive you of your statehood nor stop you from acquiring that status. So that argument doesn't fly.
And what about the arrest warrant issued for the Hamas commander Mohammed Deif, who's believed to be dead? I mean, what's the significance of that?
Well, the significance is that the ICC judges would not have known that if he's dead or not. No one knows that. People can operate on the basis of belief, but the judges need evidence to operate. So the evidence they have didn't tell them that he was dead, so they issued the arrest warrant. Of course, if evidence emerges later on that he is dead, then they will vacate the arrest warrant. But that doesn't have much of a legal significance that should trouble us.
Right. And of course, these arrest warrants, from what I understand, were initially kept secret, but we understand that one of the reasons why the ICC has released them now, they say, is because they considered it in the interest of victims and their families that they are made aware of the warrant's existence. What's your assessment of that?
Well, I cannot second, if that's what they say. Frankly, I haven't seen that. I will look at it later. If that's what they say, we have to accept their word for it. But I cannot comment too much on that.
Right. So going forward, what happens next? Because, I mean, they've been indicted, arrest warrants have been issued, and presumably the plan, sort of the broader sort of strokes of the plan would be that at some point there would be, they would turn up for trial.
They have not been indicted as yet. What we have is an arrest warrant. The ICC system was set up in quite frankly, in my view, there's a certain strangeness to it, where you issue an arrest warrant first and then do indictment later. In the other tribunals, the former Yugoslavia and Rwanda, both were done at the same time, but here they issue arrest warrants of the ICC first. So the process becomes, if there is, at the point where there's an arrest warrant, so if the arrest warrant is executed, then the judges would proceed to, the prosecutor would then lodge the indictment for confirmation, and the judges would then consider the indictment for confirmation. So that is the process of the ICC. One way to get around that is if the persons under arrest warrant offer to show up on their own cognizance to say, look, we don't need to operate on the basis of an arrest warrant. You can issue us a summons to appear, and we will honor the summons to appear, and we come and defend ourselves. So that then can speed up the process, and the confirmation, indictment confirmation can proceed along after that, and then you can have a speedier trial. But until that's done, if the accused persons, or rather the suspects, refuse to cooperate, then it will have to abide execution of an arrest warrant. It can happen when they're in office, if they travel overseas, or when they leave office, they can also be arrested and sent to the ICC.
Well, that's very interesting. I want to thank you very much indeed for taking the time to talk with us. Judge Chile Ebe Osuji was the former president of the International Criminal Court. He's also the author of the book End of Immunity, Holding World Leaders Accountable for Aggression, Genocide, War Crimes and Crimes Against Humanity. And those latter two were part of the charges against Prime Minister Benjamin Netanyahu and the former Israeli Defense Minister Yoav Gallant. And of course, George Chile Ebe Osuji was talking to me on the line there from Toronto.